लिए काम कर रही है, ना कि क्राइम बढ़ाने के लिए काम कर रही है. थैंक यू सो मच.
Professor Sougata, 3 minutes.
Sir, I have very little time, and hence I shall not make a speech. I speak on the Criminal Procedure Identification Bill 2022. I have several questions or clarifications to seek from the Home Minister. He mentioned about the Law Commission, 1980. Why is it not mentioned anywhere in the bill in the statement of objection reasons? I do not know. Why did it take 42 years for you to act on a Law Commission? There is no reply. My second question is, he has spoken of in measurements, in 2B, he has spoken of biological samples. My question is, does the biological samples include microbiological samples? That means when you take a part of the skin, it is a biological sample. When you do a DNA test, find out what the deoxyribonucleic acid is, then you do a microbiological test. What are you wanting to do? Biological, take a piece of skin, or actually do a DNA mapping? Can you afford to do DNA mapping for a patient? Third, he has said that behavioral attitudes including blah blah. And any other examination, does it include macro mapping? Does it include brain scan? That is not clear. That's why, sir, this bill is very badly drafted. Neither is biological sample clear, nor is behavioral attributes clear. This is possibly the first bill which deviates from Criminal Procedure Code. Criminal Procedure Code, an officer of the rank of sub-inspector can lodge an FIR. He is trying to give power to head constables to do measurement. And in prison headquarters, is it wise to give this power to non-gazetted employees, which has never been done in so many years of independence? He will kindly clear it. There are only two redeeming features in the bill, that for people who are arrested for an offence committed with punishment for a period of less than 7 years, he may not be obliged to allow taking his biological sample. This is a slight redeeming feature, slight window. The other is, if somebody is released, a person who has not been previously convicted, has had his measurement taken, is released without trial, then all the records will be rubbed off, eliminated from the thing. But the whole thing is basically why we had opposed the introduction of the bill. Because this is draconian. This impinges on Article 14, 20, bracket 3 and 21 of the Constitution. It takes away the right of the individual, which includes the right of those charged with an offence. I think this bill was drafted in a hurry, without any provocation. There is no reason why Amit Shah came with this bill suddenly. I would request him that he is the Home Minister, he should show some politeness and refer the bill to the Standing Committee so that all these definitions can be clarified and the misuse of this bill by head constables and head warders and small petty officials can be avoided. With this, sir, I again oppose this bill, this being draconian against the democratic rights of the people.
Sri Nishikant.